Under Section 72, proof of documents not required by law to be attested. Section 72 of the Evidence Act 1872 speak about proof of document not required by law to be attested. This section says an attested document not required by law to be attested may be proved as if it was unattested. To prove an unattested document, one must prove attestation and signature. To prove an unattested document, one has to prove the execution only. Where the law does not require attestation for the validity of a document, it may be proved by the admission or otherwise as though no attesting witnesses existed. 3. Comparison of a signature, writings or a seal with others, admitted or proved. The provision of this section will apply only when a matter is pending before the court and not otherwise. The court may compare the disputed signature, writing or a seal of a person with the signature, writing or a seal which have been admitted or proved to the satisfaction of the court to have been made or written by that person. A court may rely upon its own comparison of a signature, writing or a seal unaided by the expert evidence. The rule of prudence is that comparison of a signature by court as the mode of ascertaining the truth should be used with a great care and caution. Dispute about the genuineness of handwriting or a signature should not be decided by the court merely on the basis of its personal comparison. This section does not infringe the Article 20, Sub-Article 3 of the Constitution of India. Thus, it was pointed out by the Bombay High Court in a case before it that where the prosecution had failed to prove that handwriting and signature on a document were those of the accused, the court itself comparing the signature on the Wakalatnama with the document would not be constitute evidence of a signature and much less of a handwriting. Though the court is competent to do so, it would normally be compare signature of its own. The question as to whether direction given by the court to an accused present in a court to give his specimens writing and signature for the purpose of comparison under Section 73 of the Act infringes the fundamental right enshrined in Article 20, Sub-Article 3 of the Constitution, has been referred to 3 judges bench of the Supreme Court in view of the disagreement between the two judges constituting the division bench. Under Section 73A, proof as to verification of digital signature. For the purpose of ascertaining whether the digital signature is that of the person by whom it purports to have been affixed, the court may direct that person or the controller or the certifying authority have to be produced the digital signature certificate. The court may also direct any other person to apply the public key listed in a digital signature certificate and verify the digital signatures purport to have been affixed by that person. For this purpose, the controller means the controller appointed under Section 17, subsection 1 of the Information Technology Act 2000. Under Section 74, public documents. The documents are divided into 2 categories, public and private. This section, what comes in the category of the public document. Section 75, that all other documents are a private document. Certain mode of proof are prescribed in regard to public document as distinguished from the private document. Section 74 to 78 deal with the nature of a public document and the proof by which is to be given of them. Section 74 defines their nature and Section 76 to 78 deal with the exceptional mode of proof applicable in this case. The proof of private document is subject to general provisions of the Act relating to the proof of documentary evidence contained in Section 71 to 73. There are several exceptions to the rule which requires primary evidence to be given. The most important and conspicuous exception, however, is with respect to the proof of records and other public documents of general concernment. The objection to producing which rests on the ground of moral, not physical inconvenience. They are, comparatively speaking, not liable to corruption, alteration, or misrepresentation. The whole community speaking, not liable to corruption, alteration, or misrepresentation. The whole community being interested in their preservation and, in most instances, entitled to inspect them. While private writings, on the contrary, are the object of interest but to few whose property they are, and the inspection of them can only be obtained, if at all, by application to a court of justice. Public documents form an exception to the hearsay rule, and their admissibility rests on the ground that the facts contained therein are of public interest, and the statement are made by authorized and competent agent of the public in courts in the course of their official duty. However, statutory declaration that is a particular document is conclusive proof of particular fact or a legal right by itself does not oust the jurisdiction of the civil court. The effect of such statutory declaration is that in any inquiry regarding the existence of such fact or a legal right, courts or tribunals are forbidden from entertaining any further evidence on such an issue. The moment the document which is declared to be conclusive proof of such fact or legal right is produced before the court or tribunal conducting such an inquiry, the ouster of the jurisdiction is altogether a different matter. A document which purports a letter or report of an executive official is not a public document.